Okay, welcome back to my YouTube channel, VaJee Centre for Legal Excellence. In the series of IBC Amendment Act 2026, now we are dealing amendment in section 14 of IBC IBC 2016. Okay, here here I brought in the purpose of amendment. I brought in the purpose of amendment. Okay, strengthening the section 14 amendment done with the intention to strengthen the moratorium, protecting the values and closing loopholes. What amendments are introduced? Okay, earlier in section 14 subsection 1 is subject to only subsection 2 and 3. Section 2 section 2A, capital A is added here. Okay, this is new addition. Section 2A. What it says? It says it mandates that the supply of critical goods or service essential to managing the corporate debtor as a going concern cannot be terminated, suspended, or interrupted during the moratorium, provided the debtor pay the current dues for those supplies. Okay, what it practical implication of this amendment? It formally synchronized the stay on a legal proceeding with the professional duty to preserve the business values and assets by the safeguarding the vital supplies. No more debt by the thousand cut during the resolution process. Okay, here moratorium is when section 7 or 9 petition is admitted. Moratorium came into force. Section 14 came into play. Moratorium means other party cannot sue. Creditors cannot file a suit against that person. So, oh, but there is RPs have a professional duty to maintain the corporate debtor as a going concern. If if they cannot, they may cut off essential supplies which are very essential to continue with the CIRP. If he's paying those particular period dues, then that shouldn't be cut off. That is the whole purpose. It is earlier impliedly, but now it is expressly mentioned under section 14, subsection 2. Okay, what is the next change in this section 14? Explanation is inserted in section 14(3)(b). What it says, it expressly what is the position earlier? Earlier, what is the situation? Guarantor of a corporate debtor can file a suit or cannot file a suit. This position is not clear. There is a quite ambiguity. Uh, uh, if some creditor suing a guarantor, because guarantors are jointly and severally liable according to the contract. So, can guarantor sue the corporate debtor for the recovery and indemnity? This position was a bit unclear whether moratorium apply on the guarantors as well or not. Now, by the adding of this explanation, it is crystal clear that that prohibits of the moratorium do apply when the surety guarantor seeks to initiate or continue any action or proceeding against the corporate debtor. Now, guarantor can sue. Earlier, guarantor can sue or cannot sue. The position is not clear. Now, guarantors clearly cannot sue. So, what is the practical impact of this? It's prevent the backdoor litigations by the guarantor that would drain the asset and derail the resolution process. Ensures focus remain on resolution, not the secondary battle. We are not opening another battlefield. Okay, if creditor suing a guarantor again claiming that I have because so and so reason I have a right to recovery and I have a right to indemnity. So there is a closed loophole that just we are back to square one. So that situation now is breakdown. It is clearly guarantor cannot choose. Moratorium applies to guarantor as well. Okay. In summary way, we can say that this particular amendment it's very balanced and preserve the value and close the loophole for the better outcome for the stakeholders. Okay, hope it helps. Thank you.